My lord, may lord matter, my lord, auction, my lord, sales certificate. I'm very sorry, my lord. The
My lordship, this is Nisha. I am the litigant party in person.
Just wait. Yes.
Page number 12, serial number 51 to 58.
Yes.
List number 1 for pronouncement of order. Serial number 1.
My lordship, I am the respondent herein. I'm sorry I cannot be present before this honorable court. I'm in Bombay at the moment.
Revision petition is dismissed.
Serial number 2.
Much obliged.
For the respondent.
For the petitioners, my lordship. Allowed.
Serial number 3.
Petitioner, my lord. For the respondent.
Allowed.
Parted matter. Serial number 4. V. Mohan.
Lift up here for the petitioner.
So finally, he is waiting from the last 1 week.
I understand.
For respondent number 2, my lord.
But in this case, my lord, my first statement would be, my lord, during the pendency of the proceeding, I have cleared the entire loan amount. Auction was called for 1 crore 35 lakh 17,795. I have paid the amount, my lord.
1 crore.
35 lakhs 17,795.
What happened to the auction?
Well, the auction process, I had obtained an interim order of stay was granted by this honorable court, staying confirmation of the auction. That interim order is in force till today, my lord. It was granted on 6/2/2025.
But now you have to tell the court why should we set aside a sale that had taken place?
Because I have alleged bank fraud.
What is that fraud? That is.
Please. But I have produced the guidance value.
That's the only thing. That's the only ground.
That's the only ground.
Where is the auction notice?
The auction notice is at annexure A. Page 21, my lord.
Go to both of those. Page
21.
close. Where do you get the
My
reserve
lord, total,
price?
my lord, in the very first paragraph, it's one is they have auction, they have quoted price in two rates. One is 55 lakhs 6,000. The other rate is 80 lakhs 11,000. Total amount for which the property is measuring to an extent of 41 acres, 25 guntas.
No,
Was
one
sought
is
to be
1
auctioned
crore.
was
No, 1 crore 80 lakhs.
1 crore 35 lakhs 17,795.
No. Reserve price, I'm saying.
Reserve price was 1 crore it is.
1 crore 80 lakhs. Yes.
I'm sorry, my lord, reserve price was not 1 crore.
No, look at page 21. I'm looking at 21.
Please. Reserve price was 1 crore 80 lakhs. My lord, now, my lord, the total extent of the land is 41 acres, 25 guntas.
Hmm.
I produced the valuation slip along with the writ petition,
Where is-
guidance value along with the writ petition.
Exactly.
The guidance value is at page number. My lord, page 31 to the writ petition. Relevant. It's at column 112.
Page 30.
31, man.
Oh.
That is the guidance value, my lord. Column 112 is the column of the petitioner's village, land where the lands are situated. My lord, for coffee plantation, the guidance value fixed was 17 lakhs 50,000 per acre.
Hmm.
For 41 acres, 25 guntas, the valuation would be 7 crores 28 lakhs 43,750. My lord, throughout in this writ petition, the respondents contended that these are coffee plantations.
When you have mortgaged the property, where is the valuation?
My lord, property was mortgaged in the year 2009.
We'll see what
My
was
lord,
that.
before that, my lord, I'll make one more submission. Lord, the valuation slip report furnished by the bank is annexed on the last date of hearing, along with the memo they have furnished. How they have played fraud, my lord? It's only in one line, I'll say. They could throughout they have contended that these properties.
No, let me look at that.
First page, my lord, throughout they contended that these are plantation crops. The first page in the valuation report, my lord, in respect of agricultural land. This is the valuation report dated 28/24 obtained prior to auction. They get it valued as agricultural lands. As per the very same guidance value, the valuation of the agricultural lands per acre is.
This is on 28/2024. When this writ petition is filed?
Lord, 27 June 2025.
So where do you get that it is for the agriculture land?
No, the moment they say agriculture land, they're out of the code because Surface Act doesn't apply.
I'm asking where do you get
On the top of the valuation slip, first page, valuation report,
in
immediately
respect
below
of-
valuation report.
in respect of agriculture land?
This is the first fraud they commit because the moment they say agriculture land, the valuation is reduced by almost 12.5 lakhs per acre. They value it at 5,50,000. Lord, the last page of the valuation report. Lord, internal page 6.
Yes.
Lord, after reducing the value of the property from 7 crores 28 lakhs by valuing it at agriculture property, they have reduced it as per the guidance value, my lord, to one column above from the bottom. The guidance value of the property is 2 crores 28 lakhs 94,000.
No, acre is how much?
Per acre, if it is calculated at agriculture property, it would be 5,50,000 as per their valuation. If it is as a plantation crop, it is 17,50,000. They reduced 12 lakhs in the inception, and after that also they don't stop at this.
Now let us look at.
One more submission. They don't stop at this. The valuation is 2 crores 28. They once again reduce it by 40 lakhs. They say distress sale. This was the auction for the first time.
Yes.
But on the face of it, my lord, they have reduced the valuation by 4 crores 46 lakhs.
Shall we hear it?
Please.
Yes.
My lord, on the last date, my lord, I have filed a synopsis. That is, my lord, on 6/11/2025.
6/11.
2025. I'll just take your lordship through the synopsis, my lord. The dates and events are,
Yes.
my lord, 25/7/2008, my lord. The mortgage deed is executed and loan is advanced, my lord. My lord, NPA of 2016, my lord. Then, my lord, your lordship may kindly see demand notice is issued in February 2023. My lord, possession notice is May 2023, my lord. Subsequent to which, my lord, magistrate court order, my lord, is of March 2024. My lord, we have taken physical possession, my lord, in October 2024. subsequent to which, my lord, sale notice is issued on 2/12/2024. My lord, the successful bidder, there are 5 bidders, my lord.
This is the first auction.
This is the first auction. There are 5 bidders, my lord, in which, my lord, the successful bidder, my lord, has my lord, deposited 1,81 lakhs. My lord, that is deposited on 21/1/2025. That's the last column. My lord, so far as the maintainability of the writ petition and the grounds that are being urged.
Before
My lord,
going
initial,
into the no,
I'll
please,
just
one
make
minute, 1 minute.
2 submissions.
Before going into the maintainability,
Please.
please submit on the factual aspect.
Please, my lord, on facts, my lord, there are 2 aspects, my lord. This writ petition was initially filed on the ground, my lord, that it is an agricultural land and writ petition is maintainable. On that ground, my lord, interim order was granted. Subsequent to which, my lord, I have produced the mortgage deed.
I have
Let
taken,
us see the interim order.
I have produced, please,
When was the interim order granted?
the 2/12/2020.
my lord, 31/12/2024, my lord. May I read, my lord, the interim order?
What is that?
31/12/2024.
No, it is, nothing is recorded, though the auction sales are.
My lord, I have taken both the pleas in the ground.
Hmm.
Grounds, I have taken both the pleas.
What, both the plea?
First plea was that there is a bank fraud. Second plea was it's an agriculture property because RTC is
No,
still.
you can't, no, you cannot blow hot and cold. At one stage you say they have valued it as agricultural land. It is not an agricultural land. You
No,
want
no.
to come before this court saying that it is an
Now
agricultural
I'm
land.
conceding, my lord. I'll concede that it's a plantation crop.
Then,
If
my
I
lord, the
concede
writ
it's a-
petition is not
Concede,
maintainable.
having made a statement before the court, how you can concede? We
My lord,
can't
in
take that contrary to the pleadings.
My lord, pleading was taken because if it's an agricultural land, Surface Act would not apply.
Yes.
Then they came before the court for the first time, along with the memo, they produced the mortgage deed where it said plantation crop. In the writ petition, I had always taken a plea that the property is worth 7
So
crore.
please complete your
Lord,
submission.
please.
7 crore 28 lakhs is the
One minute.
valuation.
Lord, on I have produced the that is the initial submission, my lord, because of which, my lord, the writ petition was entertained. Because of that, my lord, I have filed a memo on 11/8/2025, my lord, in which, my lord, I have annexed the mortgage deed executed
that.
by him.
Let's see that.
Please, my lord. 11/8/2025, please. The lordships have it, my lord. In the last page, your lordships may directly go to the schedule, my lord. The schedule, my lord, all the piece and parcel of coffee estate. Please,
So,
that
now
makes it clear, my lord,
it
that
is a coffee
the
estate.
property that has been mortgaged to me is a coffee estate.
Then
My preliminary submission for that, sorry, my lord.
Valuation.
Please, my lord,
when it
I'll
is
come to
made-
that. I'll come to that, my lord. So my preliminary submission is, my lord, that the writ petition is not maintainable because this is not an agricultural land and he has to go before the DRT. My lord, insofar as the valuation, my lord,
So once it is not an agricultural land, it is, the surface of proceedings are maintainable.
Please,
As
Mila.
far as maintainability of the writ petition before this court is concerned, if he is alleging fraud on the bank, then.
It is
my
maintained.
lord,
I have the
on
judgment
fraud,
to that
my lord,
extent, my lord.
my lord, fraud is being alleged on the ground, my lord, that there is undervaluation. My lord, this honorable court, my lord, your lordship may kindly see on the very same point, coordinate bench, my lord.
Take that.
Lord, your lordship may kindly come to, my lord. My lord, para 6 onwards, my lord, internal page 6.
Yes.
It is an admitted fact that the petitioner is a guarantor and the mortgager to the loan obtained by so and so, which is under liquidation as on this date. It is also an admitted fact that due to failure on the part of the borrower to repay the loan to recover the amount due from the borrower, the mortgage property is brought to sale. The sale notice was published in newspaper so and so. Admittedly, the reserve price was so and so as stated by the learned senior counsel for the respondent. The contention of the learned senior counsel for the petitioner is twofold. The valuation of the property sold is more than so and so, whereas the property is sold at so and so. That the procedure required to be followed under Rule 8(5) of the rules is not complied with by obtaining the valuation report. Whether valuation of the property is rupees so and so as per the guideline value or more than so and so market value is a question of fact, which is to be proved by leading evidence. On the other hand, when the first respondent bank contends that it has obtained the valuation report, it is to be placed on record. Thus, I am of the view that the contention raised by the petitioner with regard to obtaining valuation report is a matter of evidence. Moreover, it is submitted that the first respondent bank has obtained valuation
Yes, sir.
report.
Yes, sir.
Please. Hence, my lord, my preliminary submission is, my lord, they will have to be relegated. Now, my lord, on facts, your lordship may kindly see
Want
the
a
valuation
clarification
report.
first on that.
Please.
Because by law, what it is, like it is all settled, we all
Please,
know
Miller.
that. I want submission on the factual aspect.
Please, my lord, on the valuation report, my lord, could your lordships take the valuation
It
report?
is clear that it is a coffee plantation.
Please, my lord.
And the guidance value should have been on the, as per the same.
My lord, I'll
Not
just
an
explain that. I'll just explain that, your lordships, why, my lord, the valuator has given such a report. It's a part of the valuation report itself, my lord. Your lordship may kindly come to page 4, my lord, that is the extent of the land.
Page 4 of the same.
Valuation report, my lord. The valuation, my lord, we have conducted the sale based on the valuation report. That's what the act prescribes, my lord. So I will place reliance upon the valuation report, my lord.
No, I have also asked you to place a valuation report of 2009.
My lord, it was my instructions on that is, my lord, that it was earlier with the State Bank of Mysore, and my lord, that report is not available. Initially, my lord, your lordships had directed, and that is why it was posted for further hearing. 2008, my lord, the valuation report, I'm told, is not available, my lord. But the guidance value report is there, my lord.
Give
Please.
that.
Copy, yeah. My lord, I have marked the relevant portion, my lord.
Where is that?
Second page, my lord, it's highlighted, my lord. I'm sorry, I don't have a copy.
Yes,
It is.
it says first column or,
My lord, 92nd, my lord.
yeah, that I saw.
That is, my lord, 9. Maximum is 1,98,000, my lord.
Per acre.
That is, my lord, it's
2009.
2006 to 8, my lord.
Yes, no, please, from the valuation report, you wanted to submit something.
Please, my lord. In the valuation report, my lord,
Is that page number?
my lord, I filed it along with the memo, my lord. 8/7/2025.
Yes.
Please, my lord, 41 acres, 25 guntas, page 4, please, my lord.
Yes.
That is the total extent, my lord. Your lordship may kindly come to the characteristics of the site. Point number 4. Level of the land with topographical conditions, slopey towards the northern side. Your lordship may now, my lord, come to the next page. Lord, on the top, my lord, unfertile red soil with sand mix. Crop is in worst condition. Crop not properly maintained, too steep valley. Now, my lord, there are remarks also given, my lord, at the bottom. The subject property is sloped towards the northern side. Unfertile soil, crops are not properly maintained, too steep valley, and extent is also very big, which leads to less marketability. Hence, prevailing market value is considered less than the guideline market value. Here, the approved valuer, next page, please, Miller.
No, guideline rate obtained from the registrar's office. What is this clarification?
Lord, the guideline rate that is obtained, my lord, is 5,50,000 per acre.
That is agriculture land.
Lord, that is, my lord, the reason is, my lord, because, my lord, it is, first of all, it is slopey. Second thing is, my lord, some portion of it, crops are there, which are in a bad condition. And also, my lord, some portion of it is vacant, because of which, my lord, we have arrived at this. My lord, ultimately, my lord, these are all question of facts, my lord, which will have to be decided by the DRT.
And let this interim order shall go on.
Please, my lord.
Let him approach the DRT.
Please.
Let DRT decide this factual aspect.
Please,
and
my lord.
till the DRT proceedings are concluded, this stay shall go on. This
Lord,
interim order shall go on.
My lord, then your lordship may give a time duration for the DRT also, my lord, because all the pleadings are almost complete, my lord.
Please come.
My lords, I am the auction purchaser. My
limitation-
interest may be protected. My money is struck for
Lord, one more
year now.
aspect.
No,
Millard.
once
My
it
lord,
is.
one more submission is, my lord, insofar as Bafna's case, my lord, this case is squarely covered by that, for the reason being, my lord, in Bafna's case also, my lord, both sides had deposited the entire amount, and the Honorable Apex Court said that to maintain the sanctity of an auction, my lord, after issuance of the sale notice, invocation of Rule 13(8), my lord, the writ petition is not maintainable, and so far no proceedings, my lord, is maintainable. That also, my lord, is a point.
Wait, see, No, when will he get an option?
My lord,
After the sale is conducted,
my lord, that is true.
created by fraud, when will, then
My lord,
what is the option
My
then?
lord, one option, why I'm making this submission is, my lord, kindly look at the conduct, my lord. The conduct, he does not pay, my lord, 2008, my lord. We started 2016 NPA, he does not pay anything for the past 9 years. And now, my lord, the amount that he has deposited, my lord, there was another auction, my lord.
Well, I'm not on the amount that he has deposited.
No, I am only on the conduct, my lord. I am
Conduct
bringing
is,
to your
my lord,
lordship's
2000
notice, my lord,
declared
how,
as
my lord.
NPA.
My lord.
Up to 2023, they keep quiet, my lord.
No, no,
because he's a
2000
late
Let him
citizen.
submit, let him submit, Mr. Khan.
My lord, 2016 NPA, my lord, he was well aware of the mortgage deed. He's well aware that there is a due. For 9 years, he does not deposit any
aware.
amount.
I'm
I'm
sorry,
just,
my
You have
lord.
to let him argue.
I'm extremely sorry, my lord. He's a
my lord,
senior
I'm just
citizen.
bringing it to your lordship's notice, my lord, the conduct for a reason. The reason is, my lord, that once the sale has been conducted, my lord, then, my lord, he has deposited the amount. How he has deposited the amount, my lord? There was another adjacent property which was mortgaged to Canara Bank. That property was also sold. Excess amount was deposited. He collects the money from there and deposits here, and in fact files another essay challenging that sale. This is his conduct. After 9 years, he comes back and he deposits the money
I'll
and
fix the
challenges the other sale.
The time frame to the
Please.
DRT to.
I'm
My
deeply
lord, and
obliged.
regarding delay before the DRT, my lord, that may be observed that we are pursuing the remedy.
The present petition is filed. Seeking the following prayer. It is a case for the petitioner. Then what about misrepresentation before the court?
My lord, I honestly believe that it's an agriculture land because I
Believe, then you forget.
I produced the RTCs.
My lord,
Till
mortgage
date, it
deed, my lord.
was agriculture land.
Mortgage
They
deed
produced the
executed by
mortgage deed
him.
and said, I have mortgaged
So
it as
then
a
now,
land.
the second, now that is, the case is improved. You
Please,
can't
sir.
take, like contradictory stance. Either you have to
I
take,
understand.
either you have to go it as an agriculture land, or you have to take it as a coffee plantation.
I'll tender apology by way of an affidavit
No apology. We will impose cost for this.
for
It has to
taking
be,
interest.
yes,
Reasonable cost, my lord.
5% of the outstanding amount.
My lord.
The
My lord,
brief
he's a
facts of the
senior
case
citizen. my
are,
lord.
the petition has availed their own. Where is your synopsis?
My lord,
Lord,
synopsis, he
memo,
hasn't
my
given
lord.
facts with regards to my status. That's a problem.
His synopsis is,
6/11/2025.
the petition has availed the loan from the bank on 25/7/2008 by duly executing a mortgage deed in favor of the bank. The property mortgage is a land at measuring an extent of 41 acres, 28 guntas,
25 years.
25 guntas.
Please.
As the petitioner had failed to pay the amount, on 9/10/2016, the account was classified as NPA by the bank. On 24/2/2023, bank issued a demand notice to both the petitioner and the guarantor under section 13(2) of the Surface Act. On 24/5/2023, the bank issued a possession notice under section 34. And the same day, it was published in newspapers as required under Rule 1 and Rule 8(1) and Rule 8(2) of the Security and Interest Enforcement Rules 2002. On 7/3/2024, the magistrate has passed an order under section 14 of the Surface Act. The physical portion of the property was taken on 19/10/2024. The sale notice was issued on 2/12/2024. Questioning the sale notice, the petitioner has approached this court. A coordinate bench of this court on 31/12/2024 has granted an interim order that the auction shall go on, but the respondent shall not confirm the auction sale till the next date of hearing. And that interim order has continued, has extended from time to time. The bank has conducted the auction and the auction purchaser has paid an amount of rupees 1 crore 98 lakhs.
81 lakhs
1 crore 81 lakhs,
on 21/1/2025.
21
1
1 2025.
5.
Petitioner has also deposited and has paid an amount of same amount,
No, my lord,
No,
1
my lord.
crore 35 lakhs 17,795. Don't amount.
35 lakhs 17,000
No,
1 crore 35 lakhs 17,795.
on
19/3/2025.
on
19/2/2025.
19 to
19/2.
Okay.
19 to 2025.
My lord, I'm sorry, my lord, 19/3/2025 and 26/6/2025. 2 dates.
19 3 and 26
6/2025.
6 2025.
Yes.
He has deposited the amount. In the writ petition, the petitioner has taken the contention on the petitioner has taken it is a case of the petitioner that the land is an agriculture land and the valuation of the property is 17 crores and odd.
7
17 crores 28 lakhs.
17 crores,
7 crores 28.
7.
7 crores.
That's his contention.
28 lakhs.
That's his.
7 crores,
28 lakhs.
28 lakhs, but the reserve price is fixed at 1 crore 80 lakhs. It is stated that it is a case that this is the first auction, first time the auction is conducted. They have obtained the valuation considering it as an agriculture land. According to him, after the respondents have filed the mortgage deed showing that it is a coffee plantation, then the contention that is put forth is that they have obtained the valuation as considering it is a agriculture land, but it is a coffee plantation. As such, the price that is fixed by as such, there is a collusion between the bank and the auction purchaser. And the bank, due to defraud the interest of the petitioner, has fixed the price. If it is submitted that unless and until the sale is set aside, it would cause a lot of hardship to the petitioner. Land counsel appearing for the bank submits that immediately after the auction, and the entire amount is deposited by the auction purchaser. You are impleted.
Please, ma'am. Application is allowed.
Auction purchaser is impleted in this writ petition. It is submitted that when the account is declared as NPA,
Nineteen 2016.
9.
NPA on 19/10/2016, the petitioner had dragged on the proceedings on one pretext or the other. It is submitted that the petitioner at one stretch takes a stand that it is an agriculture land, saying that the sufficient proceedings cannot be initiated. And when it comes to the valuation, it is submitted that it is a coffee plantation. The petitioner cannot take that kind of stance, and in fact has come before the court with suppression and misrepresentation of facts. As such, he is not entitled for any relief from this court. It is submitted that when they have obtained the valuation report, though it is a coffee plantation, considering the nature of the land and how it is situated, the valuer has fixed the rate.
Please.
Further, he has relied on judgment passed by the coordinate bench of this court in case of KV. Jay Prakash versus State Bank of India, arising out of red petition number 9800 of 2022 dated 25th May 2022, wherein when a similar stand is taken by the, when the stand taken by the petitioner therein is that the bank has not valued the property, undervalued the property. The court, uh, the court has observed that it is a disputed question of fact where the evidence is required. For that, the petitioner has to go before the DRT, and further, when there is an effective alternative remedy available to the party, a writ petition cannot be entertained. It is further submitted that the petitioner had paid this amount by selling the property, which is mortgaged to Canara Bank.
No, after the sale, he receives the additional amount, and my lord challenges that sale.
This amount is paid after one of the property which is mortgaged to Canara Bank is sold, and whatever the amount that he has received, he has paid to this bank, and he questioned the sale by approaching the DRT. It is submitted that it speaks volumes about the conduct of the petitioner, and the petitioner is not entitled for any relief from this court. Land counsel appearing for the auction purchaser submits that he is a bona fide purchaser and he has paid the entire amount, and the interest of the auction purchaser has to be protected. Next one. Having heard the counsels on either side, peruse the material on record. There is no dispute about the fact that it is a coffee plantation, and it is also an admitted fact that the petitioner has come before the court with the stand that it is an agricultural land and surface proceedings cannot be initiated. The petitioner, only with an intention to get an order from this court, it appears that he has come before this court. And that aspect will be dealt with by this court eventually. Then first coming to whether it is an agricultural land or a coffee plantation. The mortgage deed makes it clear that it is a coffee plantation. For a coffee plantation, per acre, as per the value is 5 lakh 50. What is it?
For coffee plantation, it is 17 lakhs 50,000.
17?
Lakhs 50,000. 50,000.
17 lakhs 50,000. And if it is an agricultural land, it is 5 lakh 50,000. The valuer has valued it at 5 lakh 50,000. That is as per the
Guidance.
considering as a
Guidance.
agricultural land as
Please.
per the guidance value. On the face of it, there is a lot of variance between the guidance value of an agricultural land and of a coffee plantation. These aspects have to be considered by using evidence before the by letting in evidence, and this court cannot consider all these facts while exercising its jurisdiction under Article 226 of the Constitution of India. No doubt, once a sale notice is issued, the right of the borrower, the borrower has no right to redeem the mortgage. But at the same time, if an allegation that it is prima facie placed before the court to show that the bank has not acted fairly, and the reserve price that is fixed by the because of the reserve price that is fixed by the bank, it is causing a lot of hardship and an allegations of fraud that is made against the bank. On the face of it, looking at the valuation of 5 lakh 50,000 and 17 lakh 50,000 per acre, there is a huge difference between both the prices, in spite of the fact that the petitioner has come up before the court that it is an agricultural land. No doubt, he has come to the court with misrepresentation of facts. He has not come before the court stating correct facts. Still, that this court, that itself cannot be a ground for this court to non-suit the petitioner. However, for making those kind of coming before the court with this kind of by not disclosing the correct facts, this court deems it appropriate to direct the petitioner to pay an amount of rupees 50,000 towards cost to the respondent bank.
Let it be to the Advocates Association of Welfare.
Bank. Next. In the facts and circumstances of the case, this court deems it appropriate to delegate the petitioner to the DRT, and the order that is passed by the this court not to confirm the sale shall go on till the petitioner's application is decided by the DRT. Accordingly, this court is passing the following order. The petitioner shall approach the DRT within 4 weeks from the date of receipt of the copy of this order. The interim order dated 31, what is that, 31/3,
31/12/2020.
31/12/2024, passed by this court, shall continue till the application is decided. He shall make the auction purchaser also a party to the application. The DRT, generally how much time the DRT takes?
3 months.
Generally,
Generally, my lord, 3 months, because
It's 6 months, my lord.
My lord,
6 months.
Lord,
Including the holidays, it will
because-
be 6 months, my lord.
it may be 3 months, my lord. My money has been stuck with
I have no objection.
1 year. I have taken.
as this court has, as the interim order is operating in the facts and circumstances, the DRT is requested to dispose of this matter within a period of 3 months from the date of receipt of the copy of the order.
Grateful.
Lord, one more submission is, my lord,
Regarding limitation,
just in case, limited.
DIT may not insist upon the limit.
The DRT shall not go into the aspect of limitation.
Lord, one more aspect is, my lord, if they do not approach in 4 weeks, my lord,
Yes.
then we may be
If the
permitted.
petitioner fails to approach the DRT within 4 weeks, the bank is at liberty to confirm the auction.
Please, oblige.
My
Grateful.
lord.
Till number 5. Broadest matters, till
Yes.
Respond on this case matter. Parties are agreed to.
The parties have got together. They have agreed to settle the matter, my lord, sir. The payment of about 11 lakhs and 40,000, out of which
There are
90,000
two
has been
mechanisms.
paid.
Another connected matter, my lords, in this, before the different climate, my lord, the joint form is insertion, the other matters also, my lord.
What is that?
Blood in the MFA, the.
Lords, the contention of my learned brother is that out of the same accident, 2 MBC cases came to be filed, my lord, sir. One is by the mother of the respondent in the instant case and the respondent in the instant case. This matter has come up to the stage of High Court, my lords, whereas that matter is still in the MBC stage. Now, my lords, both the matters
Filed
have
by
been
whom?
But,
by the mother of the respondent.
Oh.
By the mother of the respondent, my lords.
Who
Both
died?
Uh,
out of the same accident.
Like there are two accidents, my
and
lord.
the-
They are arising up to.
No. This accident is the same, my lords. One
I
accident.
understand.
2 people were involved. One is the mother and the son.
Mother and son died.
No, my lords.
No,
Both are
nobody has died,
injury
my
case,
lords.
injury case, my lord.
Both are alive. They are
That
saying
is,
that
it's a case of injury.
Injury.
it is a case of injury.
No,
Now, my lords,
it is a son's case which is before this court.
Please, my lord, please.
son's case is before this honorable court. In the second paragraph, my lords, it has been with the consent of the counsel at appearing in the MAC also, who had represented the. It has been incorporated that even in the case of the mother, and settlement has been agreed at 5 lakh and 10,000 rupees, which is well within the knowledge, and the mother is also present before the court.
But the different matter.
No, I don't compromise this case, my lords. I am just bringing it on record because the difficulty here is
One
that.
more.
Please.
Why should, this can be, because the matter is before this court, it can be settled.
Please,
When
ma'am.
it comes, why are you bothered about the mother's
Oh,
matter?
yes,
No, here our difficulty is that, my lords, both the cases,
understand.
they have got into a settlement. And that there is no insurance claim in this case. The entire amount is being settled by the appellant who had been the vehicle owner earlier to his transfer.
As far as the mother is concerned, the matter is pending before the MAC.
There is no doubt about it, my lords.
Go ahead.
In the event that, my lords, after the compromise of this case, if they do not admit with that case, my lords, it becomes a
Can't do
difficulty.
that. She's not a party before this court.
No, my lord. It's
That
not a
if your
party.
lordships would take that call, it is well and good, my lords. But the difficulty is that, my lords, your lordships would have seen on the earlier occasion also, even after agreeing, they had resigned from the settlement and they moved away. Your lordships would have
Kindly
observed.
remove that para, my lord. I
You know
will.
that 11 lakhs which you're giving is to him, not to the
Yes,
mother.
please. That there is no ambiguity, my lords. Only to safeguard the interest of appellant, nothing more than that.
As far as the
Without
applicant-
prejudice, my lords, it may be
We will not,
incorporated.
I'll not record any of that. Only as far as the petition is concerned, you are ready to give 11 lakhs, he's ready to take.
Please, I will
That's
read it.
that's a settlement.
Kindly remove the second para, my lords. I will agree.
There is a,
The memo.
Good.
This filed.
ಇಲ್ಲ, signature ಹಾಕ್ಬೇಕಿದೆ.
I will say, put the signature of the parties, my lord.
but the second para has to be removed.
Removed,
You're
but,
stuck, yes.
Struck down.
Back down.
How much was awarded by the tribunal?
My lords, it was 12 lakhs, 12 lakhs or 11 lakhs.
11 lakhs, 11 lakh 40,000. I think.
But here, my lords, the case was that it was an ex parte order which came to be passed, and the injuries, my lords, are not substantiated. Therefore, there is a settlement which has been arrived. And this vehicle came to be sold way back, my lords. About 4 to 5 years back, he had sold the vehicle.
RC is in his name.
RC in his name, we did not get it.
No
transferred.
insurance, my lord.
That is all the
No
issue.
insurance, that is it.
Obviously, a person who does not transfers the RC, where is he going to maintain the insurance?
Yes, please. DDS.
A joint memo is filed. This appeal is filed by the owner of the vehicle. Owner of the vehicle questioning the compensation that is awarded by the tribunal. A joint memo of settlement between the parties is placed before the court. As per the settlement, whereby the appellant owner has agreed to pay a sum of rupees 11 lakh 40,000, out of which an amount of rupees 90,000 has been paid through online transfer to the account of the respondent, and 10 lakh 50,000 towards full and final settlement of the claim is by way of a paid by way of a DD draft bearing number 132073 drawn on IDFC First Bank, Rajeshwari Nagar branch, Bangalore. Before this court, the check is handed over.
DD.
DD is handed over. DD of,
Petition.
the DD is handed over to the
Respondent.
claimant. Hence, in the light of the settlement arrived at between the parties, the MFA is disposed of. The joint memo should be part and parcel, sir. Order. Where is the delay? There's a delay?
Yes, yes, my lords, there is a delay.
PD of 1,100.
It was an ex parte order which came to be passed.
1,000? IA number?
IN number
So,
24.
in the light, Kannur. Yes.
Lords, I have also sought for a refund of the statutory deposit which has been made.
The statutory deposit that is made by the appellant, he is at liberty to withdraw.
Please.
Yes, next.
Cell number 6. This is Shivani Gowda.
It has to go before the division bench. Regarding permission to post for, that's for something it reads.
Though I have taken the contention that I am challenging only the quantum in excess of 5 lakh. That class is there. In spite of that, they have posted. Your lordship kindly para 8 up by grounds.
No, it looks as if you sought for permission.
Pardon that?
Where is the office note?
Para 8 may kindly be seen, man. My appeal. I have sought for
The
posted
appeal is-
before single judge only, but they
So,
have-
no, what is the amount granted?
amount granted is 24 lakh 70,000 my lord.
Hmm.
Out of which I am challenging only 4 lakh 55,000. That is the disputed amount.
Please come.
Remaining amount may be permitted to withdraw.
The insurance, it is submitted that though the amount that is granted by the tribunal is 24 lakhs, the insurance company has filed appeal only disputing an amount of rupees 4,55,000. As such, the same is, it has to come before the single judge. Next. Where is the IA for stay? IA number 1 of 25. Is filed seeking stay of all further proceedings. And counsel appearing for the appellant submits that. It's a case of death.
It's case of death, man.
The case of death, and on what grounds excess amount is granted?
Like the 2023 accident, 19,000 taken,
It's
15,500 has to be taken. Therefore, that is
It's an accident of 2023, and the court has taken the notional income at
19,000.
19,000 instead of 15,500.
15,500.
Instead of 15,500, that's the only ground. The insurance company is before this court, and the amount that they are disputing is 4,55,000. Considering the same, the insurance company shall deposit 19 lakhs.
20 lakhs.
It's 24. You are saying 4.55.
20. Please.
The insurance company shall deposit 19 lakhs within a period of 4 weeks, and the respondents are at liberty to withdraw as per the conditions laid down in the award, and the remaining amount, if any, shall be kept in fixed deposit.
Bill number 7, Ravi Samprati.
Notice to the respondents. Yes,
Ravi Samprati for
all the appeals have come.
Most of the appeals have come.
Yes.
But the insurance company's name is wrongly shown in the cause list of the judgment. It is the name of the insurance company is Royal Sundaram General.
That's what I
Insurance.
said. I said on the last occasion, in whose case, that I'm not going to interfere with this.
No, but I
Why
have
your
read-
people are not doing, that's your lookout, isn't it?
No, they have included only alleged instead of, in fact, have placed the incorporation
Remember, no,
certificate.
what happens is, if they have to execute it, against whom they will execute?
No, it is only general.
No, what I'll do is, now you want stay. I'll grant stay, and you have to file the
Please.
corrected copy of
Yes,
the
sir.
appeal.
Yes,
You're on what ground?
appeal on quantum alone. Mother alone is dependent. 1/3 is deducted instead of 50%.
How much
The
is
admitted
granted?
amount is 10,21,300.
21,000?
300
Hmm.
will deposit with interest.
No. What is the amount granted?
Amount granted is 15 lakhs.
15 lakhs.
15 lakhs, 57,780.
15 lakhs?
57,780.
So 10,21,000 is admitted amount.
Please.
It is submitted that the insurance company is before this court on the question of quantum. It is submitted that the land counsel for the insurance company. It is submitted that when the mother is is unmarried,
He was married, the wife got remarried after the accident.
mother is the only dependent, and the court ought to have deducted 1/3, 50%, but the court has deducted 1/3. So only on that ground, the insurance company is before this court. Considering the same stay, the insurance company shall deposit an amount of rupees 10,21,300, and the respondent is at liberty to withdraw as per the conditions laid down in the award. The next, after this is only in the IA, other order. The name of the insurance company in the order impugned is mentioned as Royal Sundaram Alliance General Insurance Company Limited. Oh, it should be?
It should be Royal Sundaram General Insurance Company. Alliance should not be there.
It should have been Royal Sundaram General Insurance Company Limited. The appellants shall file shall get this rectified and file the corrected judgment and decree within 8 weeks
Please.
from the date from today.
Please.
Yes, next.
Bill number 8,
In this, at para number 13 and 11 of the judgment, the Kannada portion of the evidence is extracted. So the officer is directed to file the translated copy of that.
When the entire judgment itself is,
Entire judgment
no,
is-
When the judgment, the entire judgment is in Kannada, then also they don't ask. Why are they asking for this?
I don't know.
Are you filing the translated copy when it is in Kannada? I don't think so.
Some courts insist on that.
No, but I have never seen.
Not before your lordship.
The office objection. The council submission with regard to the office objection is accepted. Yes.
Well,
What is this matter
Two
about?
vehicles are involved, tempo and a motorcycle.
Uh,
The charge sheet is filed against the tempo and as well as the motorcycle. But the
You
tribunal
insured which vehicle?
I'm for the insurer of tempo. The
Tempo
entire
and,
negligence,
Tempo and other vehicle is?
motorcycle. The entire negligence is fixed on the tempo. It should have been to some extent on the part of the driver of the car.
Charge sheet is filed on whom?
Both the vehicles.
Both the vehicles.
Both.
How much is
6 lakhs.
it is submitted that when the charge sheet is filed on two vehicles?
6,94,520.
When the charge sheet is filed on two vehicles, in all this say counsel for the appellant inside. When the charge sheet is filed both on the tempo and on the motorcycle, but the liability, the tribunal has fixed the liability only on the tempo. On that, the insurance company is before this court. Concerning submission 50%. 50%, 4 weeks, respondents are at liberty in all that, as per the conditions laid down by the notice. Next.
9. Chandrasekhar Patil.
What is that letter of extension?
For petitioner, my lords, the trial court has disposed of the matter, my lords, on 15th only, on 15th of this month.
Then what is this letter?
They have, I think for the safer side, they have issued this extension of time.
The honorable court by order dated so and so. The matter is now posted for respondent arguments on 10/12/2025.
On 15th, it is got
It is
disposed
disposed of.
Please.
A letter is addressed on 9th December 2025, seeking extension of time. Land counsel appearing for the petitioner submits that the court has disposed of the matter on 15/12/2025. Yes. Yes.
Cell number 10.
Memo for withdrawal.
Memo for withdrawal.
What is that?
Copy is not served upon.
He's not even seeking liberty also.
Please.
The memo is filed stating that the petitioner is not willing to prosecute the petition. And the same may be dismissed as withdrawn. Memo is taken on record and dismissed as withdrawn.
Please,
Yes, next.
oblige.
Cell number 11. Cell number 11.
For the petitioner in this case.
Yes.
There's a office objection regarding annexure A set.
That we will see. What is the mark?
I'll comply with your lordship. That's why I require 1 week time. I'll comply with the office objection.
You want to argue or shall I post it after vacation?
After vacation.
Yes. After vacation.
Cell number 12. Joseph. Sam Joseph Vignesh Shetty.
My lords, I
For the
put the
respondent.
counsel for R3 in 12.1. I pray that my name may be deleted, my lords. Mr. D. Vinagiri.
What is that?
It's application
It's
filed by
comedy,
the
sir.
advocate.
Huh?
These applications are filed by the advocate. He is on medical aid.
Huh?
Medical aid. He is suffering from medical aid.
No. On 30th, 7th.
I know that. I know that.
No, not before.
What, when the matter came up on the last occasion?
No,
No.
I have no knowledge.
No, not you. When the matter came up on the last occasion, the advocate who was appearing, I said they have to make their alternative arrangements for this. Somebody has to argue this matter. They can't drag on this. I'll vacate the stay.
Filed everybody. They also filed synopsis. We also filed pursuant to order passed by 30th, 7th, 2025. This honorable court heard the matter and said that file a synopsis and compilation of judgment, which all the party filed.
What he is filing is that he is not well.
In fact, my lord, the
Take that.
love and adjournment thereafter. Interim order, my lord, granted pursuant to my lord, we conceded. Interim order may, my lord, vacate it, my lord, whenever, my lord, they wanted to argue, let them argue. Because, my lord, I sold a property, I have to hand over the position to, my lord, auction purchaser.
It's been over 1.5 years, your
1.5
lordship,
year.
since we purchased.
Even though there is a direction to the Canara Bank, my lords, to comply the order of this Honorable Court on 2/4/25 lots. Still date, they have not complied.
No, you have
Still
not,
submit.
you have done so many things in between. That is also more important than all this. Telling the conduct of the party
It's not fair.
or the advocate is very much relevant in these cases. In fact, the division bench has dismissed your appeal to say that the court has no roster and you will file a memo asking the court to pass order on the memo. You will take it to the appeal. The division bench will dismiss it with exemplary with cost of 25,000. And now again, these grounds. In the writ petition of 2022, you will have a
21.
stay in the year 24. 21 or 22?
21.
21.
I have no knowledge.
Further, my
of
lords, in a similar manner from some memos that they had filed in the magistrate court in section 14 proceedings, they came before this honorable court, and this honorable court granted indulgence saying you deposit the money and go before the DRT. Neither did they deposit the money nor go
I
before
don't
the
have any
DRT
respect
within
towards this
time.
court order, my lord. In fact, my lord, kindly see last 4 order passed by this honorable court, detail order. My lord, I will not take more than 5 minutes in this matter. The short point is involved, my lord, it's covered by judgment. It's a, my lord,
You have to understand.
I understand, my lord.
How what is, what do you expect the court? When he says, what is that here? After fall of an iron pole on the head of the undersigned advocate, suffering acute vertigo trauma.
I
As a
will
side
say
effect, the other day he said they're undergoing ear operation.
I'll say only one thing. This honorable court, my lord, coordinate of earlier, Honorable Justice Shyam Prasad. Justice said that you file a synopsis, I'll consider. All are place the synopsis. My lord may place the matter for orders. My lord, in fact, synopsis before this honorable court. They also filed, I also filed.
This is matter as part heard. I will take up immediately after vacation.
Great.
My lords, I appear for Union of India, my lords, in 12.1. My lords, there is a challenge to a section that has been made, both of which have been upheld by this honorable court and the Supreme Court, my lords. In fact, one of the sections which were challenged earlier was by the very same advocate, and it has been upheld. He's challenged it once again here, my lords. So therefore, my lords, so that I've placed those judgments.
No, in fact,
Judgments are already
placed.
Now
These, my lords, I've already
placed
placed it on record.
Yes, you please place order.
We have placed already.
It's
Like
already
before the
on
court.
record.
One
This
J,
is
two, one
matter as part heard after vacation.
Cell number 13.
I'm grateful, my lords.
Your Lordship, I appear for the respondent, Your Lordship.
Yes. Do that. It is submitted that the counsel is unwell. On the last occasion when the matter came up, in the earlier matter, when the matter came up, this court has indicated that they shall make alternative arrangements as having obtained a stay from this court. The matter was not argued, and on one pretext or the other, the petitioner is seeking time. However, considering the fact that he has some health issues, list this matter after vacation as part heard. Yes.
What's in the previous
I said you
matter?
come to Dharwad. That's what, if you ask for time, we'll ask you to come to Dharwad. The memo is filed stating that the matter has been amicably settled out of court, and the petitioner does not intend to prosecute the case. Accordingly, memo is taken on record and dismissed. Yes,
Cell number
next.
14. A.V. Amarnathan.
The borrower has paid the amount to
Rao.
the bank, and this petitioner is the guarantor, my lordship. It's,
Memo for withdrawal. Yes.
and the bank has agreed to return the documents and all.
Yes. The memo is filed stating that the issue between the borrower and the respondent bank has amicably been settled out of the court. And accordingly, sought permission to withdraw the memo is taken on record.
Both
Dismissed
the-
as withdrawn, both 14 and 14.1. Yes, 15?
Cell number 15.
Manoj, I appear for the petitioner. Submission, Manoj. Kindly page 38 and 39 is here. I have made a submission that I do not have any of the documents. Moreover, in the impute case, I am the father-in-law.
Non taking of hand summons by the counsel for the petitioner.
Yes, Manoj, I would take, but just placing reliance on a judgment, Manoj. Kindly
For what?
Manoj, I am the father-in-law. They have sought for recovery against me, Manoj. My son is also no more, and that has been reported in the order sheet also.
Why have you taken out hand summons?
No, my lords,
Then that's how it is adjourned after vacation.
my lords, date may be given after.
In spite of an order by this court to take out hand summons. Again, today the land council petition is submitting arguments on the merits of the matter. This court, without notice to the respondent, will not hear this matter. This sit after vacation on 15th of January.
15.
Yes, 16. List this matter after service of notice.
Cell number 17.
My lord, 16, my lord, 16, my lord. I'm ready to pay the whatever the balance amount, my lord. Entire amount I'm ready to settle.
Who
Kindly, my
appears for the bank?
bank, my lord. Yesterday I was served them through email and WhatsApp.
No, if what happens, if the auction is already conducted,
Auction is not conducted, my lord. They are
I will record that. I will record that according to the petitioner, auction is not conducted.
not conducted.
And,
They're,
he
my
will
lord.
deposit entire amount.
Please, my lord. Only 1 month time. Within 1 month time, I'm ready to settle the entire amount. No issue, my lord.
Just now you said you are ready to pay now.
Yes, yes. Please, my lord. Please.
Interim order on how much you are going to pay, not like after 1 month. Immediately, what is outstanding first?
My lord,
Let us look at the 13-2.
They say that, my lord, actually the 10 lakh is the amount, my lord,
Yes.
borrowed. But they say the exorbitant interest, including all,
But
my lord,
that is
15 lakhs they are
Yes.
asking.
So we will take only that 15 lakhs as the outstanding amount.
10
When,
lakhs, my
how
lord.
much you're going to pay?
Out of 10, 50%, 5 lakhs I will deposit, my lord. Please, my lord.
15 lakhs,
Out of 10,
50% is
out of-
7.5.
Out of 10, my lord, 50%.
That's why I said when the matter came up on the first, that notice should go to the respondent.
Or
I will not,
50% of 15 lakhs, my lords.
Huh?
50% of 15 lakhs.
When you will pay the remaining amount?
Within 2 weeks, my lord.
What I'll do is,
first-
you have this amount, when are you going to pay?
Please, within 2 weeks, my lord. First 50%.
You have to pay this amount by 5th of January. This matter will come on 6th of January.
Please.
By that time, if you have not paid 7.5,
Please.
and an undertaking is not filed before this court, that remaining amount as per, by the time the bank council will come.
Let them take.
As
Please.
per that, if you don't file, if you don't pay the amount, within 15 days from there, the writ petition shall be dismissed on the ground, would be the order now. If you are ready, I'll pass.
Please, my lord, I am ready. Yes. My lord, and one more submission, my lord.
Yes.
Some leniency has to be shown for me, my lord, by the banker side, my lord, and towards the exorbitant interest, my lord. Please,
That is
my lord.
not the, that is.
At least any negotiation, mediation.
This court will not pass any of those orders. Please come. The present writ petition is filed. Questioning the position notice dated 25/10/2025. When this matter came up before this court, on 15/12/2025, this court has ordered notice to the respondent. The petitioner had made a mention before this court stating that the respondents are going to take possession of the property. Considering the same, the matter is taken up for hearing today. It is submitted that according to him, the outstanding is 10 lakhs and according to the bank, it is 15 lakhs. And he will clear entire amount within 4 weeks. And half of the amount he'll pay within 15 days. 15 days. Considering the same, this court is passing the following order. 1. The petitioner shall pay an amount of rupees 7.5 lakhs by 5th. What is the date? 5th is Monday. By 5/1/2026, an amount of rupees 7.5 lakhs shall be paid to the bank. Number 2, the remaining amount shall be paid by 20th of 21/2025/26. Number 3, if the petitioner fails to pay the amount, first there shall be stay of all further proceeding pursuant to the so and so auction notice. This, if the petitioner
Possession
fails
notice, my
if the petitioner fails to pay an amount of rupees 7.5 lakhs by 5th of Jan, the respondents are at liberty to proceed with the are at liberty to take further steps under the Surface Act. And on that ground, without going into the merits of the matter, the writ petition will be dismissed.
Much obliged.
Cell number 17. Raju.
Yes.
15.
My lord, sir, this is the classic case of judicial overreach, and if the order impugned is not interfered with, would result in what assisted abduction. This is a 3.5-year-old child's visa application to USA issue, my lord.
Yes. Yes.
No, we have sought for to apply for the visa. The interview is on Monday, on 14th one.
Why, when an order is passed
Yes.
much before,
Yes.
that you shouldn't leave the country?
I'm not leaving the country at all. I'm in fact.
Why do you have applied for it in the month of December?
Lord, I have mentioned in the application that I had applied for a US. I have an existing US visa. I've applied for my son's tourist visa. It's not an immigrant visa, as my learned friend is making it out to be. And I have given an undertaking that I'm not traveling outside at all. Since the
Why do you
interview,
want that?
no, the interview has come up. My lord, US visa applications are very
To
difficult.
make it. That's what
On,
I'm
on in the
asking.
last week of November, my lord, I mentioned in my
No,
application.
last week of November.
Yes,
When is the order of the court?
24th of November, not to take the child out without the permission of the court.
Hmm.
I'm not taking the child out of the country at all. I'm only applying for a visa. It's a 10-year visa that the child will get if the visa application is allowed.
Why is it required at this point of time?
Look, we had applied thinking it will come 2-3 months later, but we got it in 9 days.
It's okay. Don't go. No.
But I've already gone. But one process is already completed. Now it's only for formal interviews on Monday. Look, kindly appreciate this. It's a 10-year visa. I've given an undertaking to the court, and court has told me to deposit the passport in the court. The child's passport, after I get the visa, must be left with the court. I can't travel outside.
My lord, the application was made to.
Forget
My
all
lord,
that.
I will
No,
submit
one
to.
minute, one
Please,
minute.
very well.
Let that visa on Monday immediately after the formality, and once she receives the visa, I mean the passport, it shall be surrendered before the court.
That order already has been made
Then
by
what do
the
you want?
lower court. My lords, first of all, the application to obtain the visa was made only on 3rd of December. My
Court
lord,
has no time for all that.
my lord, 3rd of December, 24th
Okay.
November, the order was
Tell
made.
the
There
court
is a
about the
reasonable,
consequences.
there is a reasonable apprehension that the child will leave
Without the
with
visa,
the
he will,
mother.
without the passport, he will fly.
Once the passport is obtained, after that, what stops them from leaving the jurisdiction of this country? Where will I go? Will I knock at the doors of the Supreme
Yes,
Court
please
of
come.
US? My lords, it's only a reasonable apprehension that there is.
Petitioner father is before this court. Where is the order?
Page 68 is the operative portion. My lord,
My
page
lords, will
67,
find
68.
that as page number 23 onwards. It's annexure number A.
Operative portion, page 67 and 68.
The petitioner father is agreed with the order passed by the family court dated 12/12/2025, wherein the court has allowed I number 6 and permitted to apply and complete all formalities relating to the US tourist visa for the minor child. Unilaterally and without the consent and signature of the father. However, to balance in interest of the father, apart from the fact that there is already where is mother's passport?
With her.
First, let mother's passport be surrendered to the court.
Lord.
First, let mother surrender her passport. Once the son's passport will come, let her take that passport and give.
Lord, Monday is the appointment. She's got, in fact, she has to show an existing visa that she's got for her son also to get the visa. Lord, your lordship, I record my submission.
necessary,
Lord, undertaking, my lord, I will file an affidavit before.
Unnecessarily, protracting the proceedings.
This apprehension.
The matter, it is nothing more than that. You don't have, you won't go, but you will have a visa. You should have the stamping and all.
But
Why?
it's a 10-year visa, my lord. I have a 10-year visa. My son will also get a 10-year visa.
All these proceedings, GNWC of 50 or 20,
Yes.
25, when it will conclude?
Lord, I am not going to go, even if I'm going to go to the US, my lord, it's a tourist visa. It's not an immigrant visa where I can go and stay over there.
For all these, the parties who have all these marital disputes, I think that's only they will stop all other activity and they'll only be fighting how to litigate, how to give, create work for the advocate. That's what it
Page
appears to be.
68. Your lordship will kindly see page
How to
68.
balance
There's a direction, my
interest
lord.
of
Deposit the
interest
passport.
of the father, apart from the fact that there is already a restraint order restraining the mother from taking the child abroad to ensure compliance with the same said order. I number 7 is also allowed, and soon as the respondent gets back the passport of the child from the visa office of USA visa office, the mother is directed to deposit the passport before the court. Both are residing in Bangalore.
Both are in Bangalore.
Land counsel appearing for the petitioner submits that when there is an order directing the mother not to leave the country without the permission of the court, the mother wouldn't have made an application for the US visa, whether it is a tourist visa or otherwise. It is submitted that if once visa is granted for 10 years and if she leaves the country, the father would not be in a position to get them back to the country. It is submitted that the court ought not to have permitted the mother to apply for the visa unilaterally. Anything else?
My lords, only to counter one point, my lords, US does not issue any immigrant visa per se. Everybody gets a B1, B2 business visa, tourist visa. They jump that visa and they stay perpetually. They get married and so on and so forth. I did not have to educate this honorable court about this particular issue. My lords, there is a WhatsApp correspondence between respondent and her mother, by way of which they have expressly expressed their interest and intent to move to US, Canada, and so on and so forth. My lords, if the visa is granted, even if an application is made, 10-year visa, the child can apply at any given point in time. On 24/11, when there is a direction, the need to apply for a US visa on 3rd of December does not arise.
I think still all these still there are courts and system is running with.
Very well, my lord. So there was an order on 13/6/2025 by way of which I was granted visitation for 1st and 3rd Saturday. After 4 visitations, the mother unilaterally decided not to appear before the court. They said that the father was not being of a they alleged that the father was not of behaving in appropriate manner, and they have had shown the propensity.
What is the age?
About
3 and a half.
old. My lord,
It's a 3-year-old
the
child,
father.
3-year-old child needing a US visa on the account of welfare of the child. My lord, if we keep expanding that scope, we'll probably give reasonable opportunities for the mother to harass, take the child, go. What will the father do? What will all the fathers in the country do? That is the only intention, only reason.
You have to, your client, you should be concerned with your client.
My lord, I am very much concerned with my case, very much concerned
But
with my
he's
case.
also concerned with so many pauses.
Absolutely, very well.
Yes.
So the passport will be before the court.
My lord, the mother passport be deposited because mother's passport is
No, as
absolutely
you
not
said-
required in the US in the consulate at all.
Of course it's required.
And my lords, rather, she can reschedule the appointment up to 3 times without paying any additional fee. That exercise also can be done, at least giving me an opportunity to be heard.
No, it is on Monday.
My lord, why Monday? My lord, see the nature in which they have obtained. My lord, if at all I
Yes,
may
I understand your argument. What did you write? Unilaterally. Next one. Then counsel appearing for the respondent submits that the mother has no intention to travel. She is having the US visa when she applied for the son also. It's already part of the formalities are completed. On Monday, she's going to appear before the consulate. At this, when immediately, it is also undertaken that immediately after the after the formalities, the passport will be deposited before the court. The apprehensions that are raised by the petitioner, father, or without any basis, it is submitted that balancing the interests of both the parties, the court has passed a reasoned order, and there is nothing to interfere with the order impugned. Next one, having heard the counsels on either side, there is a material on record. When there is an order restraining the mother from taking the child out of the country without the permission of the court, and after that order is passed, there was no necessity for the mother to make an application for this visa. However, the court, balancing the interest of the father, has passed an order directing the mother to deposit the passport immediately. In those circumstances, this court do not find any reasons to interfere. Accordingly dismissed.
Like grateful minutes.
Arun Gondaraj takes notice on behalf of the respondent.
Cell number 18. R.S. Rajesh.
There's an observation, sorry. There's an observation, there was no need for her to apply for the visa. It should not hurt us in the proceedings in the custody.
But she has done it now. This observation, now it has.
Your lordship's observation will have a far-reaching effect, my lord, before the family court. That is my lord.
Yes.
Obliged.
Cell number 18.
Yeah,
Next, Rajesh.
I am for the petitioner. The petitioners are neither the borrowers nor the guarantors. The respondent number 1 has proceeded throwing out my tenants from the petition of the apartments.
The
where I
difficulty is these kind of submissions without the presence of, where is this Subhash Chandra?
Yes, for Kavita respondent.
Files a caveat and don't appear before the court. Yes, argue.
Yeah, no. The thing is, I am a co-owner. That is, I am neither a borrower nor the guarantor. The respondent number 3, 4, they have taken the loan from the first respondent.
No. Before that, please come to the cause title.
Yeah.
What is the relationship between the petitioner and the other unofficial respondents?
Yeah, I will come to it. The petitioners are daughters of respondent number 3. And brother of, that is 5th respondent is their brother. These two have mortgaged, these 3 persons. They have mortgaged the property during 2017. They have availed certain facilities, which I am not a party to that.
Please show the court what is the document in your favor.
I have filed a suit for partition. I have the Annex A itself is a suit that is plain which I have filed in the year 2020 itself.
What happened to that?
For partition, it's pending.
Then what?
It is just pending and it is reserved for judgment in this.
We can't help it. Because you are all the family members, one will take the property, mortgage the property and take the loan, and the other will come to the court.
I am
and
not
say
the
that
family member. I am already married. I have settled differently and I have let out the apartments to my
Go
tenant.
to the DRT. DRT will decide all these
DRT
issues.
is part of the jurisdiction because as per the Supreme Court judgment in their 2025 Central Bank of India case, where they cannot sit into the validity of the title or the mortgage of the property. That is what the decision
Then let the civil court come out. As on the date, no, we can't,
No,
because having taken the loan, we cannot say no. Before the court.
My lord, my bona fides may be appreciated here, where I have not just come here after issuing the possession notice. The suit is already filed in the year 2020. As per section 6 of the Hindu Succession Act, I am entitled for the share. I am the co-sharer.
You filed in the year 2020. This property is mortgaged in the year 2017. Unless and until the bank is before the court, the bank shows what is the document. How can we decide all this?
Not necessarily, my lord. If it is
necessary.
if this honorable court feels that I need to go to the civil court only, according to my word, this is a case where the possession has been, my property has been affected.
But we don't know.
Suppose if the respondent is allowed to sell the property, what should happen to my suit?
Yes.
The property, the apartment, there are 3 apartments which they have taken the possession for the demand notice that was issued in the 2021. They come and take the possession in 2025, throwing out my tenants. Is it not a clear abuse of the process of law? When that is the approach, I have just come to this court. As per that, there cannot be such a right over the property which need to be just protected. Even as per Article 300A, that gives the protection. When once that is the case, where I have come up before this law, your lordship, to seek that this shall not go on with that, unless only thing is my suit is already there. Let it be decided. It is already reserved for judgment. It is in the month of January. They are going to pass the judgment. Till that, let it be there. Later, I had no other alternative than to come up, because in the light of the Supreme Court judgment, the validity of the mortgage or the title cannot be decided by the DRT as per the Supreme Court judgment in the Central Bank of India case.
Who will decide it now?
When?
Who will decide it now? This court also cannot decide the validity of the mortgage. So there should be some other option to you. What is the option?
Option is only civil court.
So
in fact, when I would have gone if that had been the case, where my suit for partition is already pending and here he is taking the possession. Suppose if he is going to take the possession and sell the property, what should happen to me? That's how and my tenants also thrown out, and I have sought for the possession where it cannot be restored as per the same judgment. It can be handed over. In the light of this specific judgments of the Supreme Court, I have no alternative than to approach this court to see that my property rights are protected.
Yes, I can only issue notice in this, or else if you insist, I can relegate you to.
Yeah, your lordship may pass the order of a stay, interim order to stay the sale. I have not asked for to stay the sale at least. The state to be brought. They have taken the possession. They are going ahead with the sale of the properties. Should it not be sold? Suppose if they are allowed to sell, what should happen to my property rights? When the suit for partition apartment, 3 apartments are involved here now, where I have tenanted. They have thrown out the tenants using their recovery agents. And but they have put that apartments lock and key. Now they are proceeding with the sale of the property. How am I to, my rights are protected if they are allowed to sell the property now at this juncture? So your lordship may kindly issue the interim order of stay in further proceedings. I have not asked to restore the possession back now only. Your lordship may kindly issue the stay of this further proceedings in the section.
Notice to the respondent. Yes, yes.
Cell number 19. Mahesh Kiran Shetty.
For the petitioner in this case, your lords, a copy has been served to the Cosmos Bank.
Whom you served?
Just now, my lord, I received it.
Your lord, the matter may be taken up after the vacations, your lord.
Absolutely.
Okay.
My name may
Cell
be my
number
lord.
20.
Put in the name of Mr. Vignesh Shetty for the respondent.
Cell number 20. Nitin Chandra M.
For the petitioner, my lord. My lord, the petitioner is the one of the legal heir. The mortgager is my father.
Which bank is this?
TGSP Sahakari Bank, my lord. My lord, I have intimated the bank that I am one of the legal heir. Without taking into consider, they have taken only consider of my brother and my mother, and they have issued a legal demand notice.
I think
And
you must have heard the argument in the other case.
no, my lord, this is different than the other case, my lord. I have approached to the DRT and I have claimed before the same. The DRT have rejected by placing on record of civil case, where in civil case one of the defendant is appeared before any authority. The representative of estate can be considered, but here in this case, my case is surfacey. It is a special statute, my lord. I have a reportable judgment in where it has been
You are
decided.
questioning the order of the DRT, or you are questioning the proceedings under the Surface Act.
Please, my lord.
Not the judgment. Please first clear the facts.
Please,
Where,
ma'am.
what is the prayer you are seeking?
I am seeking the quashing of
Final order dated passed in SA number by the Debt Recovery Tribunal. Why have you come here? Why have you not, by having gone to the DRT? Why didn't you go? Why don't you go to
my lord. The
DRT?
question of law, my lord, where I am the one of the legal heir.
That's not everything they can. What is that big question of law that DRT can't understand and decide?
There, my lord, she has to approach to
We
the.
have to stop this procedure.
No, my lord. Even I am ready for to pay the substantial amount to my share, my lord.
The petition has questioned the proceedings. The petition is filed seeking the following prayer. When the petition has approached the DRT, why against that order, why the petition has come before this court? This court, there is no reasonable explanation forthcoming except stating that there is a question of law. If that can be decided, the question that the petition has raised are not the questions which the DRT cannot decide. Hence, this court do not find any reasons to interfere. The petition shall approach the DRT. Yes.
Cell number 21.
Disposed of. Is 21.
21 Kaveri Timaya for petitioner.
No representation after vacation.
Cell number 22.
My lords, I appeal of the petitioner.
Ajit Kalyan.
My lords, this is a matter, my lords, the second round of litigation where my lords have given the liberty to consider where the matter was settled before the court and the family court. Then it was referred to Lok Adalat, where whatever the amount that was adjusted, everything was paid before the court and everything sorted out. When the matter was referred to Lok Adalat, my lords, the respondents didn't turn up. As such, my lords, it was said that there is no settlement. And my lords.
I think the wife is before this court now.
My lords.
The wife is before this court.
Yes, no, my lords. The husband is before the court, where everything was settled before the court. Just because the matter was referred to Lok Adalat.
Where is impugned order listed?
My lords, first, my lords, I may be permitted to my lord's order, which is.
I remember this case.
Yes, my lords. And my
Come
lords,
to the- come to
only
the
one
impugned
paragraph, on 2 grounds, my lords, it has been rejected. One is on the ground of limitation.
Read that.
Yes, my lords. It's at ink page number 24. My lords, with regarding from the reserved liberty, I'll read.
No, it's 20. There is no in page 24.
Ink page,
Order runs into 16 pages.
my lords, ink page number 24, ink page number 24.
Of the impugned order.
Yes, ma'am. From the reserved liberty already.
This is an application filed by the respondent under section of the, to recall the order dated 18 and
Yes.
consequently pass about under section 21 of the.
Yes.
Hmm.
And reserve liberty to the respondent herein to question the order passed by this court, referring the parties to the Lok Adalat. If the law permits and if it is within the period of limitation, it is in the terms of the liberty granted by Honorable High Court that present application has been filed. In view of the above observations made by the Honorable High Court and so on, so the first question is whether the application is filed within the.
You're reading at paragraph number?
My lords, it's paragraph 10, my lords.
10. Yes, please read.
The first question is whether the application is filed within the period of limitation. Since the Limitation Act does not prescribe any particular period of limitation for filing application of the present nature, it follows that it is the residuary article which is applicable, and therefore the application has to be filed within 3 years from 18 to 2021, which is the order sought to be recalled under the present application. The said order sought to be recalled is dated 18 to 2021, and the present application is filed beyond 3 years from the said date on 10/11/2025. However, the contention of the counsel for the respondent was that there was stay granted in WP so and so, which extends the period of limitation. There is no doubt that by the orders dated 21/12/2023, Honorable High Court has granted stay in WP so and so. The said order reads as follows. Therefore, there shall be an interim order of stay of the orders on the date of 20/10/22 passed by the principal judge so and so, and further proceedings taken thereto till appearance of the respondent one wife. My lords, that is the thing. The learned judge comes to conclusion there is no stay of further proceedings.
This is I number 3 having been filed beyond 3 years from the date.
Yes, ma'am.
It is barred by limitation.
Yeah, it's not, my lords. Since the stay was, the matter was in WP, the matter was pending before this honorable court. There was the stay order of the orders and the further proceedings. So the
I'm not able to understand.
Yes, ma'am.
Last time, wife had come before the court.
No, my lords. Husband only had come. The petitioner before my lords was before this honorable court, saying
So
that
where she said that there was no such Lok Adalat on the day. That is the case.
they didn't appear at all, my lords. The operative portion, my
Let's
lords,
see that order
earlier.
again.
We had on the last occasion, my lords have decided that since it was our contention that once the compromise has been recorded before the honorable court and the presiding officer assigned, there was no need for referring the matter to the Lok Adalat. And my lords, I have relied upon several judgments of this court as well as the appellate court. In that view of the matter, my lords, at the page number 95, my lords, that if I may be permitted to read one para what my lords have held, my lords. If according to the petitioner, there is the joint memo and the part of it has already been enforced, as he has already paid the amounts, and is part of the obligation is completed under the law, whatever is the remedy available to the petitioner, it is for him to pursue subject to the law of limitation. This was the my lord's order, my lords, which passed. And limitation, my lords, it will be well within 3 years if the learned judge says it is 3 years, because there was a stay operating before in the writ petition. And from the date of the interim order, my lords, no proceed.
It is completed.
Yeah, please.
No, I understood. Now come to simple.
Yes.
So,
Yes.
as far as the limitation of 3 years is concerned, there is no dispute.
No dispute. It is well
So,
with,
when was the joint memo according to you?
my lords, it's on 18/2/2021.
18/2/2021.
Yes.
When did you file the writ petition?
My lords, the writ petition is filed on my lords, initially the criminal revision petition was filed.
When?
It is on, my lords, 11/12/23. That was converted.
So
into-
please. So when was the copy 18/2/2021?
Yes.
From that day till 11/12/2023? How
My
many
lords, the
days?
proceedings were adjourned saying that it was referred to mediation. It was referred to Lok Adalat again.
No. Whatever is the final order from the court.
Yes, ma'am. That is 18/2 is the joint memo. Same day, the matter was referred to the Lok Adalat. Subsequently, on 3 occasions, my lords, they produced the order.
Where are they?
My lords, in page number 46, my lords, that is 18/2/2021.
So 18/2/2021.
Yes, ma'am.
So
Case called out.
how many days between 18/2/2021 and till the day the stay is granted? When was the stay granted?
Stay was granted on 21/12/23.
21/12. How many days?
My lords, it is, my lords, I have calculated what as per the learned judge system. This is 18/2/2021. The application is filed on 10/11/25. It will be around 4 years, 8 months and 23 days.
4 years?
8 months and 23 days.
23
And my lords, from the date of interim order, even though it is considered till the appearance of the respondent wife, it is from 21/12/23 to 18/7/25, which will be around 1 year, 7 months, 20 days, excluding the COVID period, my lords, which the Supreme Court says it should be excluded.
No, COVID period will not come to, you have not come to the court. That limitation is that you are not entitled for as per the notification.
Yes, my lords, even then I'll be well within 3 years.
That's what, where do you get that breakup? That I want to see.
Well, these are the dates which I'm telling, my lords. And my lords, may kindly see page number 46 where the order.
18/2/2021.
Yes,
and
ma'am.
18/2/2022. And another 10 months. That is 1 year, 10 months here.
Yes. So that will be exactly within 3 years, almost 2 years, 9 months or something, 10 months.
Till the matter was pending, you had the
Yes,
stay.
my lords.
When was the order of
Till the disposal, this honorable court disposed of on 3rd September 25.
3rd September?
25.
When did you approach?
My lords, immediately after the order, my lords, on the receipt of the order, I filed the application.
This order was on 3rd September
3rd September 25.
So when did you receive the copy?
My lords, I've received on 21/9/25, my lords. It's reflected at page number 95.
Page number?
20, at page number 90, in page number 96, it's available.
The date on which the
23/9
applications are made?
23/9/25.
12/9/2025.
And the last, my lords, the date on which they're delivered, 23/9/25.
It is 20?
23/9/25, 28/9/25. So the last copy was delivered on so and so day.
When did you file before the
10/11/25 was the hearing date, my lords. On 10/11/25,
No, when did you file before the court?
the next page, my lords, the IA is found.
You filed on 10/11.
10/11/25.
Then counsel for the petitioner submits that this court by order dated 3rd September 2025 has disposed of the writ petition, giving liberty to the petitioner to avail the appropriate remedy, provided the same is within the limitation. The court, having considered that the limitation is 3 years, still held that it is barred by limitation. It is a submission that the petitioner has approached the court within 3 years from the date of the cause of action, excluding the stay that is granted by this court, which was not appreciated by the by the court. Considering the same, there shall be stay of all further proceedings. Pursuant to the order dated so and so, notice to the respondent, petitioner shall serve the hand summons on the counsel appearing for the respondent and file a memo by what is 28th 28th of January. By the time if the memo is not filed on the ground, the stay shall stand.
Cell number 23. K. Madhusudan Rao.
And delivery of the order, yes. Yes. 23.
To appear for the petitioners. And the petitioners have taken it.
Union Bank of India, who appears?
Yes, madam.
Union Bank of India.
You appear?
Divya Purandar is and
Can you get the instructions from the bank stating about what it is? Give the papers to her.
I'll just give them.
I will take it up before 1:30.
Yes,
Get
cell
instructions.
number 24. Sagrajam.
The petitioner has went before the Supreme Court challenging the recall and reopen applications. Not a common order was passed by the trial court, rejecting the applications on cost of rupees 10,000 and precipitating the matter to pass a judgment on.
Let's see, where is the impugned order?
Impugned order is at page number 52.
Yes. Yes.
Both parties and counsel present heard the respondent arguments on merits. Petitioner counsel submits that the witness is not keeping well and praised him to.
MC of 25.
Yes, my lord.
And,
This was filed in the year, in the month of April, my lord.
You are for the?
I'm for the husband petitioner.
You are the petitioner.
Yes, ma'am.
Read that order.
The
Which court is this?
Chikbalapur family court,
Read
Chikbalapur.
it.
Later filed two applications seeking 151 CPC seeking to recall the order dated 16/12/2025 and permit the petitioner to lead the additional evidence. Now here these two applications petitioner has maintained the details of the alleged witness. At this stage, the learned counsel for the petitioner submits that they will examine one Lakshmi Narayan Reddy. Admittedly, today the said witness is not before this court, and in spite of providing sufficient opportunity by allowing similar application filed by the petitioner on 6/12/2025, this court provided an opportunity to examine the witness on 16/12/2025, whereas on that day neither petitioner present nor is witness present nor represented. Considering the same and also sufficient opportunity given to the petitioner, this court closed further evidence of the petitioner, and that apart petitioner was provided such opportunity by recalling the matter.
It's all on IA. This
Yes,
is on IA for
IA,
maintenance. How many months the court will grant for IA? Court has to decide it within 1 month.
This application was, the witness was a bit late to the court on that day, Malad.
No, court has given the dates. Yesterday you were telling that the matter is posted for judgment on.
Yes,
what?
that's also mentioned, Malad. The page number 54 could be seen, Malad. On 18th 12/2025, if the counsel was not argued the matter, it will be judgment, pass the judgment. Then at great difficulty he has obtained an adjournment for yesterday. Yesterday also informed that this petition is filed and challenging that order, and maybe a week's time may be granted. But the matter is posted for today, Malad. Passed over now for 3 o'clock.
Then counsel for the petitioner submits that this petition, this MC is filed in the year 20 in the month of April 2025. Petitioner is the husband who has filed the MC. The court, without giving a reasonable opportunity to the petitioner, passes an order that the matter will be posted for judgment by 18/12/2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. 2025. we are looking, but why, when the court has recorded so many dates, why were you not present?
No, witness was a bit late. The order was passed
No,
at
we will see.
11:20.
No, please come here.
Yes,
In
ma'am.
in that, the IA number so-and-so is filed, seeking
Yes.
to recall the order dated 16/12/2025.
Yes, madam.
Permit the petitioner to lead additional evidence. Nowhere in these two applications, petitioner has mentioned the details of the alleged witnesses. At this
But
stage, learned counsel, when you file an application, you should tell the court like whom you want to examine.
Well, that was already allowed, madam.
That is what the court is saying.
Witness.
Learned counsel for the petitioner submits that they will examine one Lakshminarayan Reddy, admitted today, said witness is not before the court, and in spite of providing sufficient opportunity by allowing similar applications filed by the petitioner on 6/12/2025, this court provided an opportunity to examine the witness on 16/12/2025.
Madam, on 16/12/2025,
On that day,
witness was present,
neither
but
the petitioner present or his witness present, nor represented.
madam, he was a bit late. On 11:20 itself, the order was passed, madam.
Is it the problem of the court that if you don't, party will not be there, counsel will not be there?
Don't know, madam, what.
If the court wants to dispose of the matters, if there is no cooperation from the
But
advocates,
the petitioner is cooperating, madam.
court will not,
That's why the case is now for arguments, which was filed in the April, madam. I'm the petitioner. I also happy if the matter finished early.
Then
Madam, the page number 51 could be seen, madam. The order was passed at 11:20.
so why don't you argue, pass over for arguments on merit?
But this witness is important because the respondent wife has asked this question regarding this witness in the cross-examination.
Did you file the daily order sheet? Let's see the order sheet.
Entire order sheet has been produced.
Let's see how the. How many times you are absent? If you look at the order sheet.
Yes, ma'am.
Why? You file a petition, you file MC and you don't come to the court.
No, not like that, madam.
It is like that. Look at it. Look at the order sheet which is filed by you. Petitioner present and prays time to cross-examine RW1. Submits that his lawyer is out of station. Matter adjourned. Considering the presence of RW1, who always appears before this court, along with her daughter, aged about 3 years. Matter adjourned on cost of ₹5,000 and same shall be paid to RW1. She has not even filed a petition under 424.
She has not
So,
opted, madam.
then what happened on the next hearing?
On the next date of hearing, RW was partly cross-examined. Page number 47.
RW1 present. RW1 fully cross-examined by the petitioner counsel. Respondent counsel present and prays time for further evidence. No witness list filed. Respondent's further evidence taken as nil and closed. Land counsel for the petitioner submits that this month it is not possible and he wants to file some recall application. Since matter has to be conducted on day-to-day basis, once the trial starts, call on for arguments by 2011-2025. So you file an application on 2011-2025. Then the court had permitted you and directed the matter.
The application was allowed on
to be called on
6/12/2025, madam. 6/12/2025, the application was allowed.
Counsel
Allowed.
the matter may be allowed.
Yes, on 16/12/2025, my lord. On
2/12/2025, both parties present, petitioner counsel absent. Call a case again called on 11/20. Both parties present, respondent counsel present, witness absent. Case again called at 2:50 PM, both parties and respondent counsel present, petitioner counsel absent, petitioner praised time granted on cost of ₹1,000. I think the approach by this judge is very good. This is how all the trial courts should conduct the cases. No, because before the trial court, parties, advocates are taking it for granted. At your convenience, you will conduct the cases. Who is this judge? This principal judge, family court, Chikballapur, find out. Again on 6/12/2025, IA allowed with consent.
On the next day, my lord, the close was closed.
Respondent present, petitioner absent. No
Petitioner witness was absent. They were about to reach the court. By that time, at 11:20, the stage was closed, my lord.
Why? When you have to supposed to go to the court when your matter reaches.
Even-
No, at 12:20, your 12 o'clock, your matter is reaching. You
Yes,
come
ma'am.
at 1 o'clock and say, by the time I came, court has adjourned my matter.
No, he was attending some other matters and attending the court also. By that time, the
First
matter
of all,
was.
you pay this 10,000.
Pardon?
Pay 10,000 to the wife. We'll give you permission for all that. Because you have filed the case, you dragged her to the court,
Yes,
and you don't come, pay 10,000. On that, we will give you permission. If the court also will give you permission if you pay that 10,000 cost. The petitioner is before this court. And what did you write? And the petition is at liberty to file his written arguments online by serving the copy to the counsel. The order dated, it also discloses that case again called at 4 PM. Both parties and counsels present. Petitioner counsel filed IA seeking 2 weeks time for arguments, stating that he want to challenge the order dated 17/12/2025 before the High Court, and that cannot be a ground to adjourn the matter. And another application under section 151 CPC is filed to recall the order. Call on for arguments of the petitioner by 18/12/2025. Then what are you doing from 18/12?
Well,
You didn't
this
go to the
petition was
court.
filed yesterday.
So what is wrong with the order of the judge that you will go to the High Court and question it?
No, just said that I need to want some
Or
2
like
weeks
a
time.
kind of threatening that, if
No,
you don't
no,
give me
it's
time,
not threatening, my lord.
this court do not find any reasons in the order that is passed by the court. There are clear lapses on the part of the petitioner in prosecuting the matter. The learned judge is making the best efforts to see that the matters are disposed of at the earliest. This court has perused the order sheet, and the order sheet reveals that at every point of time, on several occasions, there was no appearance on behalf of the petitioner. Petitioner, having filed the MC, should have pursued it diligently. And diligently, having observed the orders that are passed by the learned judge right from the beginning, and the endeavor the judge is making to dispose of the matter, these kind of orders cannot be interfered by the High Court, and hence this court do not find any reasons to interfere. Dismissed.
Case number 25 for hearing on interrupted applications.
Yes.
Viraj,
There's no valid policy of insurance as on the date of the accident. MACT refers to that, but in the end, in the order portion, it just fastens liability.
Where is that? Let's see.
Issue number 1. The issue is to avoid a repetition of a respond number 2 has examined RW1 and stated lorry was not insured with the company as on the date of the accident. That is
Paragraph number?
Para 9, madam. I'm sorry. Ink page 15. Petitioner suffered head and facial injuries. The violation of law is not wearing a headband at the time of the accident. The alleged accident is self-accident caused by the petitioner while going. That was my defense, of course, along with his friend at the time. But in a cross-examination, she states that we have checked the police records at the FIR. The first present on 3/1, it should be 3/1/2009 on the driver of the lorry number so and so. She says that maybe her company has not insured. The police have lodged final report on the lorry driver so and so, saying that it is not related to her company. Exhibit P8, she says, is not insurance but proposal form. In the final report, they will enter the lorry.
Court has not given any finding in this.
It
These
is
are
not
all-
given any finding. In fact, they produce on proposal form. It is only a proposal form that did not fructify into a policy. And that
They have
too,
not paid any amount.
they have not paid any amount.
The land council.
MSCD does not refers to that in the.
Land council appearing to the insurance company submits that. What is placed before the court is the proposal form and there is no valid insurance policy. Though having regarded the said contentions, court has not given any finding in that regard and held that the insurance company is liable. Questioning the same, the insurance company is before this court. Stay 50%, 4 weeks.
Before this court.
Any notice to the respondent.
Cell number 26, Jill P. Straw.
Why it should be sorry? Why it should be dispensed with?
So I sought for an interim order of stay.
No. Why the certified copy of the judgment should be?
Because in the connected matter, I have produced it.
What is that number?
So all before the division bench, all matters have been.
It is submitted that the petitioner, there are other connected matters, take that in so and so. He has already put, which are pending before the division bench. They have filed the certified copies. As such, I number 3 of 25 is filed seeking dispensation of the certified copy of the judgment, considering the same. It is dispensed with and I number 3 of 25, dispensed with for the present and I number 3 of 25 is allowed. Yes, what is the?
Contributory negligence 50-50 has been made.
That's your case.
Yes, my lord.
How much is it's a case of death or injury?
Yeah, it's a case of injury.
How much is granted?
Below 2,16,321 is
Yes,
award.
the land council for the insurance company submitted that there is a contributory negligence on the part of the claimant, which was not considered by the tribunal. Considering the submission, 50%. They can withdraw because it's only you're saying on.
Out of 50%, 50%. Division bench is also said like that.
Huh?
Out of 50%, my share, my contribution to the accident in question, 50%.
No,
I will
you
deposit.
say that, no, 50% is your if you're accepting 50% liability, then why shouldn't you file?
No, my contention is that it's 100% liability on the car driver, not on myself. So the vehicle was stopped in a standing vehicle, he came and hit from the rear portion. Proceeding only on the basis of the police records, but there's a 28 feet road which is available for the car to move on. And a vehicle which was stopped before the hospital, he came and collided with the bus from the end portion. The tribunal has apportioned 50-50, 50 on the bus.
Submitted that in the connected matters, division bench has granted permission to withdraw 50% from the 50% amount, half of the amount. Considering them, they shall be stay 50% and from that half of the amount, the claimants are at liberty to withdraw. Notice.
Cell number 27, Ravi Samprati.
Yes.
The appeal on negligence, motorcycle and lorry was involved in the accident.
Case of
Negligence
death
on the
or
part-
injury?
Case of death.
How much is awarded?
23,53,792 is awarded. We'll deposit 18 lakhs.
It is submitted that the insurance company is on the ground that there is contributory negligence on the part of the deceased, which was not considered by the tribunal. Considering the submission, the insurance company shall deposit 18 lakhs within a period of 4 weeks. And on such deposit, the claimants are at liberty to withdraw as per the conditions laid down in the award.
Cell number 28,
And the remaining amount shall be kept in fixed deposit.
Serial number 28 and 29 is connected with MFA 9324 of 25. Your Lordship has ordered notice and stay yesterday.
93?
9324 of 25. Serial number 28 and 29 are connected.
Same in both 28 and 29, IA is filed seeking dispensation of the protection of the certificate copy of judgment as already they have filed in the other MFAs. IA is allowed. Then same, take that number in same order.
Please.
Cell number 30. Cell number 30. Nirmala K.
No representation after vacation.
Cell number 31. Chikki Siddesh.
Here for the petitioner, my lords, in compliance with the lord's direction to file the translated copy, I'm producing the translated copy, my lords, of the petition and the statement of objection filed by me.
What is the amount granted?
Lords, 4,55,000 arrears that the respondent is claiming.
Let's see the order, RPSC order. I mean criminal misdemeanor.
My lords, the impugned order is at annexure.
Filed by the petitioner under section is available allowed with cost of ₹1,000 is entitled for maintenance of 10,000 per month. Pay above monthly with amount to the petitioner well in time without pay.
That is the basis, my lord, and which was passed in 2018.
What were you doing from then?
I have paid, my lords. Subsequently.
Now the execution is filed.
Yes, my lord.
Now the execution is filed.
Subsequently, the section 9 application came to be allowed, and both parties filed a joint memo, and the matter was settled, and both have decided to reside together. They started residing together.
Where is the joint memo and how
My
it is
lords,
settled?
in my memo, my lords, I have produced the order sheet. My lords, at page 12. At page 12.
The matter is taken up before Lok Adalat. After conciliation, both of them have agreed to live together. And in view of the memo file, they have agreed to withdraw all the cases. In case the case is accordingly disposed of.
Yes.
Where is the award?
Lords,
There is no separate award.
there is no separate order. All the cases have been, the recovery petitions which has been filed by the wife has been merged with the settlement, my lord.
After that,
From
what
10
happened?
to 2022 to January 2024, we lived together, and I have taken care of my wife. I have not neglected, which I have been clearly stated in my statement of objection, my lord. The statement
So
of,
from Jan 24, she is not residing with you.
she is residing in the rented house, my lords. After that, we both came together in Bangalore and find out on rental house, and rental agreement is also produced, my lord, at annexure B. Both are residing together. I have not neglected. Even till today, I am paying the rent and the monthly, even maintenance of 10,000.
How much you're paying now?
Now I am paying 8,500 my lords per month.
500 from when?
From the day when I entered into a rental agreement, my lord.
What is the date?
My lords, it's June 2022.
June 2000?
22.
There is a question of paying from June 22 when both of you are residing till Jan 2024.
My lord, the settlement was arrived on 10/2/2022.
You were residing together accordingly.
Yes. We were residing together. We were then
So you were together till Jan 2024.
2024. Yes.
No, that there is something is missing in connection between the facts you are stating. You submit that till Jan 2024 you are staying together, and you have after that you have taken out a rental premises, and you have been paying her 8,000.
No, from 2022 itself, I entered into a rental agreement. We started living together.
So now the wife is residing in the same house.
In the same premises.
What is the rent to that premises?
8,500, my lord.
Then
The
what is your income?
Pardon?
What is your income?
My lords, take home salary is 90,000, my lords.
So
Yes.
at least from even if you calculate from January 2024, as you admit that both of you are not together.
Yes, ma'am.
So 2024 till now, it will be a month less than 2 years. That is 23 months.
24 to 25 January.
24, 25 January.
Yes.
Then again 26 January.
Yes.
We are in December.
Yes.
So it's almost 23 months.
Yes.
23 into 10.
But there is no subsisting order, my lords. For that, she has to file a
No,
fresh
there is an
maintenance.
order against you.
That has been merged, my
No,
lord.
no.
That has been,
Please
that has been
understand.
culminated.
You have questioned an order before this court.
Please,
You need some order.
please.
For that, there should be a payment.
Yes.
So how much you're going to pay?
No, there is
Is
no
it-
order of
There is no
maintenance as
order.
on date.
If I
Yes,
have
my
to
lord.
suspend it, I will pass order only on that. Otherwise, I'll order notice. Wife is staying separately from 24. Forget about, she is asking it
My
from
lords,
2018.
Separately in the sense, my lords, she is staying there. I am also going there, but not on a daily, day-to-day basis. I am not residing there, my lord.
But you have to, there is a,
I have my
she is a
mother. I
wife.
have to take care of her. I have.
That's why I'm saying from
Yes, ma'am.
2024 till now, the arrears at some amount you need to pay. I don't say arrears. So on that condition, I will grant stay. What is that amount?
My lords, my lord, when there is no subsisting order,
Again, you're coming
My
back to that. That I understand.
I'm not saying she is not entitled, my lord. She is very much entitled.
I
for
will also not
maintenance.
say that there is an order.
But that order of maintenance of 2018 has been settled, has been culminated into a settlement.
If you want an interim order, pay an amount of rupees 1.5 lakh. Or
How
else
much,
I will have it after vacation. 1.5 lakh.
That's just difficulty, my lord. And
Your
apply.
salary is 90,000 per month.
That's, I have other expenses too, my lord.
So how much you'll deposit?
My lords, when there is no subsisting order, may kindly,
You understand what the court is trying to say?
Yes,
I
ma'am.
understand what you're saying.
Yes, my lord.
Yes. Some amount on that I'll grant an interim order.
I can
Or
pay
else you can-
25,000 for 25,000. I can pay.
25,000 no.
It's difficult.
I'll give you time till 8 weeks to deposit the money.
Please, ma'am.
The petition is before this court. Where is the impugned order?
Impugned order is at annexure. Page 32, my lord.
The wife, the petition before this court is the husband. Wife had filed the execution petition before the court. In that, as a petition is not present before the court, court has issued a arrest warrant. Learned counsel appearing for the petitioner submits that have you filed a petition before the court saying that execution is not maintainable?
Yes, my lord. The
It is
translated
submitted
copy is
that
also
the
produced.
execution petition that is filed by the wife is not maintainable. It is a contention of the learned counsel for the petitioner that earlier an order was passed in criminal miscellaneous number 484 of 2015 dated 25th January 2018, whereby the court has granted maintenance of 10,000 to the wife. So it is submitted that on 12/3/2022, the matter was taken up before the Lok Adalat, and after conciliation, both of them have agreed to live together and filed memo in that regard. It is submitted that there is no order to be executed, but still the court has entertained the execution petition. He has also raised the issue of maintainability. It is submitted that by the learned counsel for the petitioner that till Jan 2024, from the date of the order of the Lok Adalat, both the parties were living together, and from till Jan 2024, the merits of the matter will be considered upon the respondent enters appearance, balancing the interests of both the parties. This court deems it appropriate to stay all further proceedings pursuant to the order dated what is the date of order? 4/11/2025.
Yes.
4/11/2025 on the condition that the petition shall pay an amount of rupees 1 lakh within 8 weeks. Or else the stay granted by this court stands vacated without further reference to the court. Notice to the respondent.
Cell number 32.
I may be permitted to hand delivery to
Yes,
the
hand
council.
delivery of the order.
And hand delivery.
Cell number
Notice.
32 and then
Hand
the
summons.
other.
Hand summons.
Because it's RPFC, let notice go.
Please, ma'am.
Cell number
I think
32.
execution is pending.
Execution
The petition is permitted to take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 20th of January 2026. Yes, 32.
And the IA one for delay not pressed
Which one?
in that matter only. In the
Hmm.
31 only.
IA 1 of 25 is dismissed as not pressed. Yes.
Cell number 32.
For petitioner in this case, my
Vijay
lord. Respondent.
Mahalakshmi.
The case had been listed yesterday itself, my lord. My lord had already dictated the order, my lord. Only the operative portion has
Yes.
to be corrected.
I'll leave it to the court.
Same order. In view of the same, in the operative portion at point number 10, it shall be corrected as the husband shall pay an amount of ₹10,000 each to both children.
Great, my lord.
Yes, 33.
Cell number 33.
I appear for the petitioner, my lord, in the first case. That case, my lord, there are two loan accounts, two different properties are mortgaged. At one, my lord,
I said no arguments today, only the affidavit that has to be filed before the court, or else both the writ petitions has to go.
No, my lord, the other petitioner is not before the court, my lord.
Petitioner is one and
I
the
just-
same.
I'll just-
Advocates are different. So if you talk to the petitioner, that's fine.
No, the problem is, my lord, the petitioner, my lord, has disposed of both the properties, my lord, by way of GPS. In my petition, he is represented by a GPA holder, my lord, Irfan. In the other petition, my lord, he is represented by a GPA holder, my lord, his name is Imtiaz. My lord, This kindly- is the difficulty. I'll just, my lord. But there are two properties. Not, the lordship may,
We cannot go into the merits of the matter now.
please, I'll just, my lord, I have taken loan, my lord.
Court has shown enough indulgence in this matter. If the affidavit is on
No, no,
record, I have to
in
indicate the
my
interim order that is
loan
filed.
account, in my loan account,
He has
absolutely,
come.
please.
Where is the affidavit?
Filed affidavit within 6 months,
Huh?
6 months,
Why will they grant 6 months time for that amount of 8 lakhs?
2016. 16, all of amount is paid, my lord. Without
That
due.
affidavit, we'll see what is that.
Entire amount was paid. 42 lakhs is obtained from the respondent bank in 2016, my lord. And 10% also paid 86,000 on 15/4/2025, my lord.
Yes, Mr. Vignesh.
My lord, it can't be considered. The reason is this. First and foremost, my lord, without my permission, my lord, they alienated a property which, my lord, now it is forthcoming before this honorable court. That is one aspect. Therefore, my lord, they are not entitled for any relief from this honorable court. Second aspect, my lord,
Alienated in the first matter or the second matter?
first matter. in
First
respect of
matter,
this-
first
this
matter.
petition.
His matter.
In respect of second petition, my lord, that day, my lord, kindly see the interim order granted. The
I remember
council
that.
undertook
I
before this
remember that.
honorable court saying that I'll clear that loan.
As on that day, my lord, I was not aware.
My lord, petition is the same. He can't.
No, I'm going to
my lord,
dismiss this
he can't
petition.
approve it, reprove it.
I'm going to dismiss this petition. A party who comes to the court by mortgaging a property to the bank and he sells the property and still he seeks indulgence from this court, which this court will not. So now I'm going to dismiss this petition. Please come. Give that, first.
My petition, and I have few submissions.
And your writ petition also as we are in view of the RBI guidelines.
I can't
Your lordship may kindly
regularize.
appreciate.
I can't regularize that.
Your lordship may kindly appreciate, not challenging, not the sale notice, not I went to the DRT. Your lordship may kindly turn to page 42. my
First of all, let me dismiss this. Which one is this?
My lord, 7959 of 2000.
7959.
59 of 2025.
WP 36845.
lord. 36845, my lord, is my petition.
Your petition.
Yes.
Give the other one.
7959 of 2025.
First petition.
The writ petition is filed seeking the following prayer. The coordinate bench of this court. On 18/3/2025 has passed an order that there shall be an interim order of stay till the next date of hearing, subject to the petitioners depositing 10% of the outstanding amount within 4 weeks from today. Any deviation in paying the amount within the timeline as stipulated would entail vacation of the interim order and would also run the risk of dismissal of the petition itself. It is submitted with the land counsel of the petitioner that as per the order passed by the court, he has paid an amount of rupees 86,000.
Please, 10% of the
86,000, which is 10% of the outstanding amount. Then counsel appearing for the respondent bank submits that the property which is mortgaged to the bank is sold by the petitioner, and he is not entitled for any relief from this court. The learned counsel appearing for the petitioner also does not dispute the fact that the property which is mortgaged to the bank is sold by the petitioner. The petitioner